Criminal law definition of terms. Part 6. Relevant evidence. Evidence having any value in reason as tending to prove any matter provable in an action. Material evidence. Evidence is material when it is directed to prove a fact in issue as determined by the rules of substantive law and pleadings. Competent evidence. Not excluded by law. Direct evidence. Proves the fact in issue without aid of inference or presumptions. Circumstantial evidence. The proof of fact or facts from which, taken either singly or collectively, the existence of a particular fact in dispute may be inferred as necessary or probable consequence. Positive evidence. Evidence which affirms a fact in issue. Negative evidence. Evidence which denies the existence of a fact in issue. Rebutting evidence. Given to repel, counteract or disprove facts given in evidence by the other party. Primary/best evidence. That which the law regards as affording the greatest certainty. Secondary evidence. That which indicates the existence of a more original source of information. Expert evidence. The testimony of one possessing knowledge not usually acquired by other persons. Prima facie evidence. Evidence which can stand alone to support a conviction unless rebutted. Conclusive evidence. Incontrovertible evidence. Cumulative evidence. Additional evidence of the same kind bearing on the same point. Corroborative evidence. Additional evidence of a different kind and character tending to prove the same point as that of previously offered evidence. Character evidence. Evidence of a person's moral standing or personality traits in a community based on reputation or opinion. Demeanor evidence. The behavior of the witness on the witness stand during trial to be considered by the judge on the issue of credibility. Demonstrative evidence. Evidence that has tangible and exemplifying purpose. Hearsay evidence. Oral testimony or documentary evidence which does not derive its value solely from the credit to be attached to the witness himself. Testimonial evidence. Oral averments given in open court by the witness. Object/autoptic profference/real evidence, those addressed to the senses of the court, sight, hearing, smell, touch, taste. Documentary evidence. Those consisting of writing or any material containing letters, words, numbers, figures, symbols or other modes of written expression offered as proof of its contents. Burden of proof. The duty of a party to present evidence on the facts in issue necessary to establish his claim or defense by the amount of evidence required by law. Presumption. An inference as to the existence of a fact not actually known, arising from its usual connection with another which is known, or a conjecture based on past experience as to what course human affairs ordinarily take. Conclusive presumptions, jury et jury. Based on rules of substantive law which cannot be overcome by evidence to the contrary.